Hello, everyone. Benjamin Sanchez. I'm here with Sanchez Law Firm. We are presenting you another second Saturday series of our firm where we give you legal advice and practical advice for both consumers and attorneys, all about consumer law, real estate disputes, and business disputes. Today's webinar is going to be focusing on construction disputes. The title of today's presentation is Building Confidence, Navigating Residential Construction Claims under the Texas RCLA. Now, the Texas RCLA is a big statute and covers a lot. So rather than do a deep dive today, what I wanted to do is kind of give you an overview of construction claims and then what type of projects there are and what type of common disputes there are regarding construction projects. Then we'll cover what is the RCLA, then how does the RCLA work, how do you protect yourself and minimize your damages, and then finally we'll do a brief highlight of other laws that may apply to your construction claim. Now, I'm a 25-year attorney. I've been doing consumer law and real estate law for my entire career, and I believe that we see all types of claims here, and we get all types of people coming in. It's very important for both consumers and attorneys to know how to look out for these claims and what potential causes of action you may have, what the damages are, and how you may proceed with these claims. So let's first review the different types of residential projects and the types of disputes that come up with those particular projects. The first type of project is what we call a new home construction. Mainly, it's a tract or production home. In other words, there's not a whole lot of choice. You're not doing a custom home. So we have a new home production home still under construction. What makes these kind of projects the way they are? Well, first of all, the buyers, the potential buyers, they do not own the land at the time that they enter into the contract to purchase the home. And they will not become the homeowners until the construction is completed and the closing is done. So at the closing, you pay the purchase price and then you become the homeowner. But before that, you do not own the land or the home. Up front, the buyers pay a small earnest money, and they may pay for some costs of upgrades that may be offered at the time that the design is agreed to. The architectural design of the home is predetermined and only slight modifications are available. The builder is typically building many homes in a neighborhood, and they're just, it's a tract production. So production line, assembly line of homes being built, and you're buying one of those homes with slight modifications. So what type of disputes may come up with such a project? Well, as you can see on the screen, we have several. One is the failure to timely complete construction of the home. Next one is failure to follow the plans and specifications and provide the upgrades that you wanted and you paid for. The other one is defective or poor workmanship. The next one is a demand by the builder or contractor to accept the property with defective or incomplete work. In other words, you believe there's something wrong and they want you to sign off on it no matter what. And then the last one, the typical dispute that you see, are price increases and reductions and terminations of the various aspects of the job. So that is a new home without a custom home, okay? Now we go to a custom home that is still under construction. Typically in this situation, the buyers do own the property. They own the real estate upon which the home is going to be built. And they own that property before they even hire the builder. Whether that property has a mortgage on it or not is irrelevant to this type of dispute. The buyers do have the right to select and hire the builder of their choice. The buyers have the opportunity to negotiate the terms of the contract. And remember, this is a custom home, so you have more leeway in determining what it is that you want in the home and exactly how you want the home to be built. The buyers, most buyers don't have the money to afford a custom home, so they do obtain a construction loan to fund the project with payment applications that are done throughout the process. So, in other words, under a traditional mortgage, the home was already complete, and you're buying the home, and that mortgage comes in, and then it's just paid all at once at the closing. Under this type of custom home scenario, the mortgage company knows you already own the land, so they're basically funding the construction of the home. And in order to preserve their capital, they're not going to give you that money all at once. They're going to cooperate with you and the builder to make payments throughout the construction process. And there are some tricky points in this because you have to make sure that you're not taking advantage of in this process. And then the other characteristic, as the buyer usually does have the right to terminate the project and replace the builder. Sometimes, if you do have a construction loan, the lender is asking for approval to have their approval before you do so, because obviously it's their money, and that home is ultimately going to be collateral for the loan. So they're going to have a lien on that home with the money that they've spent. So, what type of disputes do we see in these type of projects? Well, we have everything from project delays to completion issues and also abandonment. Quite frankly, if someone gets their money, they just may abandon the project, or if they go out of business, they may abandon the project. We also have issues of increased project costs. So you think you've agreed to one price at the very beginning, and as you go through the construction, the contractor or builder says, well, it's going to cost you more for this or that. There are issues of project accounting. So, in terms of how the money that is being paid to the contractor is being spent and accounted for, there are issues of project accounting. Are the materials and supplies being bought, and where are they being bought from? Are they being bought for a good price? Are all the accounting measures in place there so that you can then look at the accounting and potentially do an audit of the costs at the end of the project? The other issue you may have is unpaid subcontractors and material suppliers. So in Texas, subcontractors and unpaid material suppliers may end up having a lien on the project if they don't get paid. So that is a very big issue that needs to be dealt with. And we'll talk a little bit more about how you can protect yourself later on in this presentation. Another issue, obviously, with any project is poor workmanship. Another issue is failure to follow the plans or specifications. Now, again, this is really important in a custom home because obviously you want the home built according to the plans and specifications that you agreed to, that you delivered to the builder or contractor. And if they don't follow it, then they're not following what you want for your own custom home. And then you may have project closeout issues and final releases. So you may have issues regarding what they call punch list items. So things that need to be taken care of at the end of the project, before a project can be closed out. And then you may have final releases. So there are you want to make sure that all the subcontractors and material suppliers have issued releases so that you know that everyone's been paid and you don't have any problems with potentially having a lien on your home. The third type of project that you may have is you have a completed home construction disputes. It doesn't matter if these are production homes or custom homes, but these are disputes that arise after the construction project has been completed. So a completed home is any home that is no longer under construction or being remodeled or repaired. Okay, so what we're talking about is those projects that are finished and they've already gone away. What type of disputes may come up for those kind of issues? Remember, these issues may appear right away, or they may appear years later down the line. So you can have construction defects. You may also have a defect that's discovered during the construction process, but that was left for post-construction punch list correction. In other words, you know during the construction process there's a defect. There's a promise by the builder to fix it before they turn it over to you. And they're going to add it to a punch list because they don't think it's a structural issue, for example, and then they just never get to it, right? You also have a defect that is discovered after the construction, a day or two later or years later. You have issues of whether or not there are any violations of an express warranty that you may be given by the builder or the contractor. There are also issues of violations of implied warranties. In Texas, we do have implied warranties under the law that may uh, exist separate from any express warranties. Most builders will try to say the only warranty is the express warranty, but that's not true under the law. So you may have violations of implied warranties. And then, of course, you have just breach of contracts for things they failed to do. The biggest category of residential construction projects where most claims fall under is the next one, which is a residential remodel project. You get a loan or you have money, but what you want to do is you want to have some or all of your home remodeled, and you hire someone, whether it's to do a roof, a bathroom, or whatever. So most of the time, these type of projects, if we look at the left-hand side of this next slide, will be interior and exterior improvements to the structure, and that may include, as I listed, foundations, kitchen remodels, bathroom remodels, room additions, floor replacements, painting, interior mechanical systems, windows, doors, and appliances. Okay. You also may have interior damage to the structure that's caused by water or fire or um, other issues that are covered by your homeowner's insurance. So you may have some of the interior stuff that we talked about. And then we also may have some exterior things, such as repair and damage caused to the roof system, the HVAC system, fences. They may be caused by wind, hail, rain, or some other covered insurance issue. What kind of things come up in those kind of projects? Well, we have uh, a lot of times of what we see is we have work that's performed without permits and licenses. Texas does not necessarily have licenses and make contractors go and get licenses to do work. So that's one of the big areas where we see a lot of complaints is that someone is doing work and didn't get the proper permits or didn't have the proper licenses to do the work. We also have disputes over payments. So we have a homeowner who is dissatisfied with the work and they want to withhold payments. And the contractor says, no, I did the work. I did it to what I think I should get paid for. And therefore, I'm going to place a lien on your home or I'm going to sue you for the difference. So these issues of payments come up. We also have project delays and abandonment. So whenever you enter into a construction project, especially a remodel, there's all sorts of things that can affect whether or not that project is on time, such as how viable is the company that you're hiring? Are you hiring one man who's going to go hire some other people he doesn't know to help him on the job? Are you going to hire a big company that does this kind of stuff all the time? What is your viability to get the work done, to have the manpower and the financial power to get the work done on time? Sometimes you have people who abandon the job, whether it's voluntary or accidental. So sometimes maybe they just they go out of business and they can't keep it up, and so they abandon any existing jobs. Sometimes we see that contractors will run off with the money, especially if they've been paid too much money for the work that was done. And again, we'll talk about how to minimize your damages by slow paying or paying according to progress as opposed to paying up front. And then you also have defective or non-conforming work. So the work itself just is not conforming to construction standards or it's defective, right? So you have all these type of things that come up in residential remodel projects. And the last type of general category of projects we have are going to be pool, outdoor living spaces, and landscaping disputes. So generally the outside of your home. These projects may be new or remodel pool construction. We have several cases regarding pools. We also have new outdoor living spaces. They may be patios, kitchens, and sports courts. Okay. We also have pond or lake construction or repair. And then we may have driveway or sidewalk repair or construction. What type of defects come or what kind of disputes come with this type of project? We have design defects, defective workmanship, works performed without permits and licenses, delayed progress or completion, and disputes over payment. So a lot of things that you've seen for the interior work and the completion of a home construction in general do apply to these type of projects. So now that we know what type of construction projects there are and what type of disputes may come about as a result of those individual types of projects, let's move on to the number one law that does apply in Texas to residential construction projects, and that is the RCLA. The RCLA is the Residential Construction Liability Act. Well, what does it, how does the RCLA work? The RCLA, it should be noted, is not necessarily a substantive law on its own, but is more of a procedural law about how things should be done before you can go file a claim in court. So it's really about a process that's set up to allow the contractor or the builder to potentially resolve the dispute before you go take it to court or arbitration if there's an arbitration clause. The RCLA really has two big components. You have your pre-suit demand, and then you have your response to the demand, which may include right to inspection and other things. So let's kind of go through this. In the pre-suit demand, the homeowner sends the builder or contractor a demand letter with specific details of complaints. Now, the law does outline kind of what kind of specificity you need, but you really need to try to be specific, right? You can't just say, well, my plumbing doesn't work, right? If you know that there is a particular leak somewhere, you need to identify that leak. If you think there's a leak in your roof, you can't, you need to try to identify that. If you have a cracked wall or mold or whatever the case may be, you need to specifically identify your complaints in the pre-suit demand letter. You also need to identify what it is that you're seeking. What is your demand? Okay, so you have to identify that in the demand letter. We could do a whole separate seminar on exactly what the demand letter says. Suffice it to say that most people do not feel comfortable doing their own demand letter because they don't want to fail to meet the requirements of the RCLA. So they end up hiring an attorney to usually do the demand letter for them. It's possible you can do your demand letter yourself. You don't, as a homeowner, you don't need an attorney. It's not required. But if you don't comply specifically with the requirements of the RCLA, then the onus of the builder or contractor to respond may not be there because they didn't get a correct and completed demand letter. Now, once the demand letter is given to the builder or contractor, they have 35 days to respond, Now, we do call this a 60-day demand letter because the entire process is going to take about 60 days, and we'll kind of go through that. So the builder does have 35 days to request documents showing the defects and repairs and to request an inspection of the home so they can see what it is that you're complaining about. So again, if you send them a demand letter, it is best to try to send them as many documents as possible to minimize them asking you for documents as part of their response. But they are allowed to ask for documents that show receipts for repairs, what repairs were done, photos that show the defects, all that kind of stuff. Okay, and then again, they can request an inspection. Once they are able to get those documents and the inspection, then they have 10 days from that point after the inspection to then submit an offer of settlement to the homeowner. So in my slide, I say basically it's 45 days after they received the demand. So there may be a question is if they ask for the inspection sooner than the 35 days, then are they limited just to the next to 10 days after the inspection? So just understand that this is not a hard and fast rule. When I do these type of claims, I generally try to work with the builders and contractors to give them some time. However, if they do miss that 35-day mark and it's a really contentious case or whatever the case may be, there have been some times where we've held fast and said, no, you missed the 35 days and therefore we're not going to honor your request for documents or an inspection. But sometimes it's to your benefit to allow an inspection even after the 35 days because it may result in a settlement offer. Now, once there's the offer that's made by the contractor, the homeowner has 25 days to accept or reject the settlement offer or state in detail why the offer was unreasonable. So you have two issues, right? You want to make sure you get a reasonable offer that you can either accept or reject. But the other thing is that if you feel like that the offer was unreasonable, you are permitted to state in detail why the offer was unreasonable. If the homeowner does not offer or state why the offer is unreasonable, so if you as the homeowner don't give that response to them, so you either don't accept it or you don't state why it's unreasonable, then the offer is considered rejected after those 25 days. After the homeowner's response, okay, whether it's a 25 days have passed with no response, or there's a rejection or a request for additional, an unreasonable complaint, the builder or contractor does have 10 additional days to supplement their original offer to deal with, potential the rejection or the reason why it wouldn't be, why the offer is unreasonable. So you got that. So again, this is a framework that allows things to happen before there's a lawsuit. The other thing is that the RCLA does encourage mediation. So the mediation, ideally should happen before there is a lawsuit. So if you have an offer, if you have a demand, and you have an offer, and you have a rejection, then it's best to do a pre-suit mediation. If the dispute is $7,500 or more, then that mediation is required. And let's say you file the lawsuit, the court could then order y'all to go to mediation to deal with that claim. So generally, I try to do a pre-suit mediation if possible, especially if we get a response from the builder. If we get no response, then it's kind of hard to set up a mediation at that point. So we've been going through the different types of construction projects, what kind of disputes there may be, and the RCLA. I know this has been a quick overview, and we'll kind of continue to go a little bit more. But what can you do as a homeowner to protect yourself and minimize your damages? Well, as you'll see, there are things that I recommend, and quite frankly, in these seminars, I do like to focus on how consumers can protect themselves more than the specific details of the law. I may go back to the RCLA, and we'll talk about some other laws that apply as well. But this is not meant to be a total deep dive on the RCLA itself, and that's it. So, what can you do to protect yourself as a consumer and as a homeowner and minimize your damages? Well, one, you want to do your research before you agree with any builder or contractor for them to do this work, whether they're building a new home, a custom home, they're doing remodel work or outside work. You want to make sure that you vet the builders and contractors. You look at BBB, the Better Business Bureau. You go to the Texas Attorney General's website and see if they've got any complaints. You might want to do, if you can, do some court research to see if there are any cases involving these people. Are there any news media articles, or whether it's television news or newspapers? But you really want to evaluate and vet the people that you're considering to do this very important job for you that is going to cost you some money, right? You want to make sure you do your homework beforehand. I'm a big proponent of going to the family doctor before you go to the surgeon, right? So I'm the surgeon, and you really don't want to see me if you can avoid it to begin with. So do your homework on the front end, okay? The other thing that I see a lot of people not do is do they don't agree to a payment progress plan. So in other words, homeowners are told that they have to pay either all the money up front, or they pay 50% up front and another 50% in 30 days, regardless of the progress of the job. Understand that in Texas, uh, again, subcontractors and material suppliers can have a lien on your home if they don't get paid. In the construction industry, there is usually a 10% retainage that is standard in the practice. It usually happens with commercial and public projects, and more so than residential. But your lenders who do construction loans definitely will know about this retainage. So usually 10% of all the payments are withheld, so that you then have this retainage fund at the end that will allow you to then pay off subcontractors or material suppliers who are not paid or who make a claim that they haven't been paid. So what I suggest is that beforehand, when as part of the agreement, that you and the builder agree on a payment schedule, according to the progress of the job. Now, people will tell you that they need additional money up front to buy the materials and supplies, so therefore it's skewed a little bit. But they should be able to break down how much those costs are versus how much the project costs are in terms of labor and those kind of things. So it's okay to make sure they get at least what they need to start in terms of materials and supplies, but then make sure that there is some sort of progress. What are the progress markers to indicate how much money should be paid at this time? You're not expected to be a construction expert, but there may be markers that both you and the contractor can agree to, or you and the builder can agree to, that would then indicate that a payment is due. So, for example, you may have a foundation. If the foundation is laid and it's solid, you've got your foundation, regardless of what kind of foundation it is, that may be the first payment. And then you may have the outside structure of the job. That may be another payment. If you have multiple stories, maybe you have, the the wood outside structure built on the first floor, that's one payment. And then you have the second floor, that's another payment, right? And then you may have the outside facade, right? The bricks or the wood or whatever it is that you're going to use, the hardy plank, whatever that facade is. You may say, okay, well, the completion of that will then be the next payment, and so on and so forth. So you can go through sheetrock, right? There are ways that you can figure out what are the markers that then allow you as the contractor to get paid. So you as the homeowner are going to make sure that y'all can agree to a payment schedule that is something that can be seen and can be decided upon. So, for example, I do not like to advise my clients to say, we'll pay you a quarterly payments on 25%, 50%, 75%, 100% of the job. Because how do you know what 25% of the job is? How do you know what 50 or 75% of the job is? It's very difficult to know. You may be told, well, all this other stuff is really little that I have to do inside. The majority of the work was really the framing and the foundation or whatever. So they may get a lot of money from you or demand a lot of money from you based upon percentages when that may not be the case. So try to be aware of what kind of obvious markers you can have in construction that would then indicate that a payment is due. The next thing that you can do is be involved during the construction process, and that because you want to also note and address any rising costs or increased time delays, right? So if you just hire someone and you're not really thinking about that project, you're not involved in that project, there's no oversight of that project, then the contractors and builders are, they have room to potentially increase the cost without you knowing, saying that they're necessary. They also may have the ability to delay the project because they don't have enough men. If you're monitoring that project, at least from a third party perspective, kind of witnessing it, you'll know, when they have sufficient labor on the job to get that phase of the project done on time versus when they have one or two guys that show up, right? So you really need to monitor the job and be involved in the process. Now, builders and contractors will have their own foreman. A foreman is someone who kind of oversees the job, right? They have superintendents, but really it's the foreman who's on the job. And so I don't think they're going to be very appreciative of you questioning the foreman all the time. But what I'm suggesting is that you at least somehow be a witness to the project so that you can see whether or not there are things that you need to be aware of, such as time delays and increased costs, those kind of things. If they want to tell you there are weather delays and you've been out of town and you just go somewhere, how are you going to know that there are weather delays? If they say, well, um, we had as many men as we could, but they only had one guy on the job, then you can, and that part of the job really needs multiple people, and quite frankly, most of construction needs more than one person. Then you can question them about that. The other thing you could do that sort of goes along the line with this, so that you don't necessarily have to do it yourself all the time, but you may consider retaining an inspector or a separate contractor who's going to regularly inspect and evaluate the construction during the process. Now, quite frankly, um, most builders and contractors are going to be wary of this kind of person. So that needs to be discussed, if at all possible, when you hire these people, right? Say, I'm not going to hire you unless we have the ability, and it's in writing, that we can inspect certain parts of the job as they're being completed. As you tell me something is completed or whatever, we should be able to inspect it. We should have another contractor, and I understand that the cost may be raised. So the question is whether or not this person is going to be sort of full time with the job as they go along, or they just kind of check in every so often, whether it's every week or every month or whatever the case may be. So you have to figure out based upon your costs and the needs of the project about this person. You also want to be wary of the separate contractor trying to take the work from the original contractor. I think that's one of the main concerns that contractors think about is that, well, this second person is just going to complain about me and really just try to take over the job and kick me out and get the money. So what you also need to do is make sure that your contract with the separate contractor, if you hire one, clearly states that this contractor will never be given the opportunity to take over the job. That their job really is for your protection and your benefit to make sure that these people who are actually doing the job do the job correctly, timely, without defects, all that kind of stuff. So just make sure you don't have a contractor who's trying to outdo the original one and if you have that kind of agreement, quite frankly, with that contractor, that is something that you potentially could show the one that you hired to build and ease their concerns that, hey, this person is not going to take over your job. This person is just here to help me make sure that I'm comfortable with what you're doing because I don't know what I'm doing here because I'm not a contractor. So it'd be like me as an attorney trying to do some sort of construction job, with my hands and everything, and I don't really know everything I know. Now, of course, I know a lot because I do this field, but you wouldn't want me building your home, right? And then the final thing I think you can do is you can address all your concerns. You can address the defects. You can address the punch list items. And again, the punch list is those things that are left till the end that everybody knows needs to be corrected, but they're considered minor enough that they can deal with them at the end of the project and just keep going with the project. You can deal with those concerns, defects, and punch list items with the builder or contractor at the end before you sign any final paperwork. This is very important. If you sign final paperwork that closes the job or that allows a final payment to be made to them, whether it's coming from you or whether it's coming from the lender, then you're going to have some issues. So you need to make sure that you address your concerns, defects, and the punch list items before you sign off on anything that's final. Because once you sign off, you may never see resolution of your concerns or the punch list items. So you need to make sure that you are satisfied and that all concerns are addressed, at least you are aware of, before you sign off on any final payment from the bank, any final agreement that the project is closed. I would also, you're probably going to find some paperwork that says that you were totally satisfied, that, you've reviewed it or whatever, and, be careful about signing those. I will mention this. Sometimes the law does say that you have to rely on the representations of the person who's defrauding you to have a claim against that person, and that when you have a third-party inspector come in, that negates that reliance because now what you're doing is you're relying on the inspector review as opposed to what they're telling you. So just remember, I'm not saying that your claims will go away when you have an inspector or a third-party contractor, but there may be some arguments later down the line that you are relying on your inspector or contractor. So those issues may come up. I don't think they kill your claim, but those are things that someone may say. Now, the other thing that we're going to be looking at is that, quite frankly, the RCLA while it is the biggest law regarding residential construction projects in Texas, there are other laws that do apply. And remember that the RCLA is more of a procedural framework rather than substantive laws. What I'm going to go over here on this next slide are what type of laws, substantive laws, that do apply to construction claims. So the first one is the biggest consumer law of Texas, which is the Deceptive Trade Practices Consumer Protection Act, also known as the DTPA. In that law, there's all sorts of things about misrepresentation, and that's, we've covered that in other webinars. We'll cover those again because that's a law that comes up often in the type of practice that we have. But the DTPA does have substantive laws that violations could result in damages, right? So it's the DTPA itself does have also a pre-suit demand framework that, in a way, kind of mirrors the RCLA, except for the issue of inspection and settlement offer. But there is a 60-day demand letter that's required as part of the DTPA, and they have 60 days to respond and try to resolve this situation. The other thing that you have is you have the Texas Prompt Payment Act. So there are issues regarding whether or not there's going to be prompt payment by the homeowner. And let me just pull up something here because I want to give you a little more detail. So there are certain timelines that have to be abided in order to pay a contractor or a subcontractor. And if those timelines are violated, then you may have a violation of the Texas Prompt Payment Act. The act says that a property owner must pay its contractor within no later than 35 days from the receipt of a written payment request. The deadline is extended if the homeowners obtained a loan for that construction or improvements. And then it's, in turn, the contractor is required to pay their subcontractors and suppliers that portion of the payment that's available to them no later than 7 days of when they get receipt of the payment. And then those subcontractors must pay their people within 7 days. So first you got a 35-day, and you got a 7-day on down the line for everybody else. If you do have a good faith dispute, though, there is an exception, so you don't have to pay if you have a good faith dispute. And again, we may get into a whole separate webinar on the Texas Prompt Payment Act. I don't want to really go over into too depth for that. The other law is the trust fund statute. The reason why I have handcuffs as the icon is because this is one of those statutes that do allow for civil and criminal penalties. So someone may be liable criminally under the trust fund statute. Some people call it the construction trust fund statute, but that law does allow for civil penalties and possible criminal liability. And again, I think we'll end up doing a whole separate webinar on that. If there are issues regarding defrauding someone, that may come under the trust fund. We're dealing with money. Again, there's all sorts of guidelines and amounts and stuff. But just be aware that the trust fund statute does exist to potentially deal with money issues and fraud in construction cases. For example, you can't get money and then spend it for something else when it really should be paid to the contractor, the subcontractor. So there's issues of trust. So you get money from, let's say, a bank, that money should be used for construction. You are considered a trustee of that money that's really going to be rightfully due to the contractor. And if you take that money and you spend it, then you can violate that. So as a homeowner, you want to be very careful. So that's something else that applies. And then we have non-statutory law, which we call common law. So these are these things that you really hear of in terms of breach of contract. They just violate the contract. You may have those issues. Negligence. So negligence could include that defective work that we talked about earlier. So someone didn't mean to do defective work, but they were negligent in their work. It's quite frankly better to use the statutes, but you can also use as an alternative cause of action negligence. This especially goes for those lawyers out there, right? So when you're doing your petition, you have all these different causes of action, and you can, and the alternative, you can also use the common law. Then you have breach of the implied warranty. All right, so you have breach of implied warranty, you have breach of express warranty, but you have common law causes of action in addition to the statutory laws that we've talked about in this proceeding. Um, so given that we are recording this in advance, we really don't have a true question and answer, but if you have questions regarding this, then I'll be happy to try to address those by email. If you email those to info@sanchezlawfirm.com, you can, again, you can email those to the info@sanchezlawfirm.com. If you're a potential client and you have questions, then we do have a formal analysis that we can provide for your case. It will give you a legal rundown of, what the law is and strategy is that applies to your case, and then you can decide whether or not you want to execute that strategy with us. So you can talk to our people about setting something like that up if you want. If you're an attorney, again, I'm happy to answer questions. I want to try to avoid the specific case by case questions, but if you have general questions or sort of light questions regarding a case you may have, I'll try to answer those as best I can. Otherwise, we need to set up a formal analysis or a discussion with an attorney and a referral. On this last page, we do have our information about what we do. We have our contact information. I really want to thank you for being a part of this presentation. I enjoy doing these second Saturday seminars, and unfortunately today I had to do it on Wednesday instead of Saturday, but that is for a good reason, folks, because I, as your Texas consumer lawyer, I'm always invested in growth of the firm and growth of my employees. And so my associate Douglas Alford and I, by the time you're watching this, we are going to be in Atlanta, Georgia, attending the 2024 spring training of the National Association of Consumer Advocates. So every spring they have a 4-day conference, and consumer attorneys from around the U.S. come and try to learn more. In this particular training, we'll be learning about solar panels, car repairs, and car repair claims and other things. So I look forward to teaching you more on that. We do have some upcoming seminars. I want to tell you what's coming up for our future second Saturday. Next month, on my birthday, May 11th, 2024, when I'll be turning 55, I'll be discussing lemon law. Lemon law, again, does not apply to used cars. It's a specific process that Texas has to deal with complaints about new car problems that are repeated problems. And so we'll get into the nitty gritty of lemon law next month in our May second Saturday series. In our June second Saturday series, we will be talking about car repair claims. Again, this is coming off the heels of this training that my associate and I will be going to, but anything you want to know from a broad perspective about car repair claims, we will be dealing with that. So you take your car to a mechanic, what can they do? What kind of liens do they have on your car? Can they charge you storage? All those kind of questions that you may have, we will try to get those answered for you in our car repair claim in June. And then finally, our next second Saturday seminar in July will cover solar panel claims. So again, we're going to take the information that we're learning, and then we're going to distill it down and then give it back to you as attorneys and the public. So in July, we have our solar panel claims, which we have a lot of solar panel claims in Texas. We have a lot of ripoffs. We have companies going out of business. We've got finance companies that don't care that the solar panel company is ripping you off. So we're going to talk a lot about solar panel claims. We're also going to talk about the federal holder in due course rule that may help us allow us to make claims against the finance companies and the lenders for the problems that the solar panel companies and installers have. We're going to learn more about that this weekend, and then we'll pass that on to you in July. I want to thank everybody for your attorneys. The CLE number is going to be 174-234-785. Again, that's 174-234-785. You will get an hour's worth of CLE credit for this presentation. And you, just like every month going forward, we'll have it. And we also have some that are going to be on demand that we're converting into CLE credit. So we'll let you know as soon as those are up. What we want to become a resource for both the public and our fellow attorneys in the areas of consumer law, real estate disputes, and business disputes. Thank you, everyone. Benjamin Sanchez signing off for April 2nd Saturday seminars. Goodbye.